host Amy Dash, and I'm joined by LawNewz trial analyst Deborah Blum, and we're going to talk about, welcome, thank you for being with me.
I'm so happy to see you again. It's been a little while.
I know, you look beautiful.
You too.
Thanks. Red's a great color on you. So we're going to talk about what we just heard. This was a clip where basically you have the prosecution trying to say that because Luis Toledo tried to kill himself in the police station after viewing these pictures of the children and going through the interrogation, that that's enough of a nexus to prove consciousness of guilt to let the case go forward. Can you explain to us what is consciousness of guilt?
Well, consciousness of guilt is a concept that means that a person is aware of a fact that they are guilty of committing a crime. So it's exactly as it sounds. It's something that would lead us to believe that person is showing guilt. So it can be used in court. It's used as evidence against the defendant, and obviously it goes to show, it's like circumstantial evidence or direct evidence even, that they're guilty of a crime. I guess you would say it's circumstantial evidence. It's another layer that the prosecutor is using to bolster their case in this matter. I don't agree with the judge's ruling here. I don't think that this should have come in. He was not a suspect or was not told that he was suspected of murdering his wife and her children, so I don't understand why this is coming in. I think that it's way too prejudicial. I understand that the state offered case law that supports it. To me, you know, maybe this guy was so overtaken by emotion that his wife and children were, or her children were missing, that's why he tried to commit suicide.
But then when the interrogators ask him, what do you think? Do you think that they're out there? Do you think that they're dead? He doesn't say, I think that they're gone and my life is over. He's not crying or upset. So what, I mean, I guess we would have to put ourselves in his mind to realize why he would attempt to kill himself without even knowing whether they're alive or not. Well, a lot of people hold out hope.
Of course. I think that in this case, the prosecution has a very strong case, and I really don't see a way that he's not going to be convicted. I think we have DNA evidence. I think we have so many things pointing to him being the perpetrator of these crimes, including his statements where he admits to say, or he says, I'm not going to show you where the bodies are, or something to that nature. So I think that's enough. I don't think then the judge needs to continue, in my mind, to poison the juror's mind against this defendant, because to me then it's an appealable issue. Again, I know that the state...
Well, let's talk about that, because I would think go hard or go home. Throw everything except the kitchen sink in, whatever you have to bolster this case. But you're saying, no, that could actually turn against them at the appellate level. How so?
Well, it's the prosecution is doing their job. They're saying, look, he gave this confession. He was aware that it was being videotaped. He knew that if he was going to go into the bathroom and commit suicide, that's all being filmed. So I understand why the prosecutor is moving to introduce this, and their application was granted. But as the defense attorney, there are some things that there's also case law that is going to say this shouldn't have come in. It's too highly prejudicial. It's something that should remain out. But then again, I don't think that this one single issue would form the basis for an appeal. It's kind of like the kitchen sink thing, where if there are a lot of issues for appeal, then together their cumulative effect could lead to an appeal. I don't see that in this case. I'm certainly not suggesting it. It's just this individual ruling, I think, is incorrect.
So let's try to flesh this out, because I saw with the Deborah case, right, that was overturned on a technicality related to a juror, knowing about a poisoning that wasn't allowed in, that she had attempted to poison her husband. This was a woman who did a murder for hire on her husband and was ultimately convicted. But my point is that we've seen cases overturned on what would seem to be or appear to be smaller issues. So why do you think that the whole case couldn't be overturned if they get a conviction on the fact that this video of him trying to kill himself was introduced?
Well, with Deborah, as you said, that was a juror issue. So I think that carries more weight, because you're entitled, it's a constitutional, fundamental right, a fair and impartial jury. And that juror was not fair and impartial. You know, she wasn't voir dired, I assume, on could you keep that out of your mind? And then everybody else in that courtroom would have been exposed to that fact, which the judge had made a ruling they were not supposed to know about. So I can see why that case was overturned for that reason. Here we have a ruling that the judge specifically made. Yes, the jurors are privy to the judge's ruling because they are going to see this videotape. However, it's a different function. It's the judge versus the jury. So to overturn the judge's ruling of law is a higher hurdle, in my opinion.
I see. And you know, it's really interesting because a lot of people, when they hear about this case from the get-go, without really getting into the nitty-gritty of the evidence, they think, how in the heck can somebody get a conviction on 2 first-degree murder charges, a second-degree murder charge? It's a death penalty case, and there's no bodies.
I think that maybe what we'll see is he won't be convicted with a death penalty. He won't be sentenced to death. It's possible, though. I think that there's enough evidence linking him to this. I think that they are doing an excellent job, the prosecution, of laying out what happened here. We know that she was having an affair. You heard testimony from the person she was having an affair with. He said, I saw the defendant come to the workforce and have an argument with Yesenia Suarez. So that's perfect motive. They've got that there. Then you have DNA evidence. You have items being dumped in a dumpster that are linked to this defendant. And it just makes perfect sense. You also have testimony that she didn't withdraw money from her bank accounts. She didn't go to get a new passport or use a passport. So I think that the state is really anticipating these issues that come up for people when they don't have a body. You know, they showed the jury the stuffed animals that were found in the dumpster that this guy threw out. You know, there was a neighbor testimony saying, yes, I went with him to the dumpster. He disposed of items in the dumpster. So I think they're really plugging up the holes here, and they're going to get a conviction.
And you had mentioned the victim's paramour, you know, her workplace affair. And so I'd like to listen to some of his testimony because I found him to be one of the more convincing witnesses to take the stand.
Now, you got back from Uganda, is that correct?
Yes.
But nothing happened.
No.
So nothing happened between you and Mrs. Suarez until you went to Alabama, isn't that correct?
Correct.
Nothing actually physically happened until you went to Alabama, is that correct?
That's correct.
But prior to that, you all had been flirting with each other by text or however it was you did that, is that correct?
I believe so, that's correct.
Okay, well, when was that code put in?
The code was when we got back from Alabama.
Oh, so that was after, okay. But prior to that, you all were communicating about hooking up, weren't you?
No, prior to Alabama?
Yeah.
Prior to the visit in Alabama, we were not communicating about hooking up.
So are you saying that basically 2 weeks before you went to Alabama, you didn't know you were going to have sex with us?
Oh, well, okay, yes.
Prior to Alabama,
yes.
right?
Yeah.
So you did know, right?
Yeah.
Try not to speak at the same time.
Sorry. So you did know?
I did know.
Okay. So from January to sometime in September, there was no physical activity, but you were sometime in September beginning to flirt again, is that right?
Yes.
And then made arrangements to have an affair when you went to Alabama a couple of weeks ahead of time, right?
Yes.
Okay. So you knew what was going to happen when you went to Alabama. That's
Yes.
what I'm getting at.
Yes.
All right. Now, on the day that everything happened, as far as Mr. Toledo finding out about the affair, you found out that he knew from Ms. Suarez, is that right?
I got a call from him.
So is that the first time you knew that he knew?
Yes.
So it was, you found out from Luis Toledo himself,
Correct.
who called you himself.
Correct.
And the first time he called you, he asked to meet with you, didn't he?
Can't remember if it was to meet with me. But it was, hey, I know about this. And
He wanted to talk about it, right? He wanted to talk with you about it, didn't he?
are you asking that question?
Yes.
Well, he was talking on the phone with me. He was talking on the phone with me, yeah.
Mr. Dredden, when he called you, he told you that he knew what was going on, didn't he?
Correct.
He told you that you don't remember if he told you if he wanted to meet with you, but he said that he had text messages, didn't he?
Correct. Correct.
You deny the whole thing.
I denied it.
You lied to him.
Correct.
And then you asked for the text messages. Is that correct?
Can't recall if I asked for him.
Okay, well, when the state attorney asked you, you said you asked for the text messages and he sent you the text messages. Do you remember saying that just a few minutes ago to the state attorney?
I actually don't remember saying that.
Okay.
I asked for the text messages, but I know that he sent them.
You don't know if you asked for them.
And you're saying just now, he said, I asked, he asked that question and I said, I asked that. I don't recall that just now.
You don't recall that?
Yeah.
Okay.
But I asked for the text message. I don't recall it.
Out of fairness, I don't recall hearing that question.
Okay. May I approach the witness, Your Honor?
Yes, sir.
This would be the transcript of the audio recording interview, page 20, line 17. May I approach?
You may.
Okay.
So did you refresh your memory?
I did.
Okay. So when police asked you about it, you said, starting at line 17, that he was persistent to talk. It's the same call, right?
Okay.
He was persistent to talk, so I started talking to him. And I was like, well, look, man, send me the text messages. You said that, right?
Yes.
And we'll talk in 30 minutes. Do you remember saying that to him now?
Yes. And I'm sorry, I don't know if I can talk right now, but
No, sir.
No? Okay.
He sent you those texts, didn't he?
He did.
You still denied it even after that,
I deny what?
the affair.
I did.
I'm
I
sorry.
did.
Yes, sir.
Yes.
Now, at some point, you get back to your place of business and you speak with Ms. Suarez about what's going on. Is that correct?
Yes.
So she's naturally upset and tense about what's going on, right? I mean, everybody's been found out.
Yes.
I mean, your boss knows, but your wife doesn't know, right?
My boss did not know.
Well, he was screaming out whatever he was screaming out.
My boss?
Not your boss. Mr. Toledo came to the workplace right after that, right?
Yes.
He was telling everybody, right?
Yeah, he was screaming, yelling. I don't know.
So your boss heard it.
My boss heard it. I believe so.
Okay. Later on, you went home and you told your wife what happened, but you didn't tell her about the affair, right?
Correct.
So after you get out of your car from where you had been, I'm back in the morning. I know I jumped around a little bit. So I'm back in the morning. Now you're back to your place of business. You've talked to Luis on the phone. He sent you the text messages. You see Ms. Suarez. Is that correct? At the office.
Yeah. So, yeah.
She tells you that, well, I don't want to put words in your mouth, but I understood you to say in here that she was upset. Is that correct?
That she was upset?
Yeah, because everything had been found out. Naturally, right? Stressed?
Disappointed? I don't know
Disappointed.
if I used the word upset or not.
Okay.
But yes.
Whatever word you used,
Okay.
concerned, whatever it was, everybody wasn't feeling right. Is that right?
I would agree.
Okay. shortly thereafter, Mr. Toledo shows up at the workplace. Is that correct?
Shortly thereafter,
Speaking with him?
yeah, we spoke, yes.
Okay. You spoke outside, and Ms. Suarez was there as well. Is that right?
I'm sorry,
You spoke to Mr. Toledo at your place, but that was in the parking lot. You went outside to smoke a cigarette. Is that right?
I was outside already, yes, at that time.
That's when you drove up, right?
Correct.
Okay. When he came up, you indicated that he was upset with you. Was he?
What do you mean, when he came into the office? When
Yeah.
he got
He got
out
out
of
of
his
the
car?
car and saw you, and you walked over to him. Was he upset with you?
Well, yeah.
So you're not surprised that he was upset with you, are you?
Was I surprised that he was upset with me?
Yeah.
I don't think so, no.
Okay.
Yeah.
And you're not surprised that Mrs. Suarez would be upset that these two particular men in front of her are arguing in the parking lot of her business, are you?
What do you mean arguing? You said these two men arguing?
That'd be you and Mr. Toledo.
I don't recall arguing.
Okay, whatever it is you recall, sir, whatever conversation, however you want to characterize it,
It was an argument, though.
Okay.
You said
Allow
argument.
him to finish the question. Go ahead.
however you want to say it, Mr. Toledo is there and you were there talking about an affair you were having with his wife in the parking lot of that business. Isn't that correct?
Yes, correct.
Okay. He and you separated, is that correct? You went your separate ways, isn't that right?
I departed. Yeah, I left back to the office.
Okay.
Well, I mean, and I'm just sorry for the questions, but just the clarity of it is just what is why I'm asking a question to you.
Okay.
Clarification.
So if you walked one way and he walked a different way, is that separating?
Yes.
Okay, so you separated. You walked one way and he walked a different way, is that correct?
Correct.
Okay. Later on, a few minutes later, however long it was, you heard him inside the office, is that correct?
Yes.
He was upset, is that correct?
Yes.
Do you know what he was upset about?
The affair. Yeah.
Okay. He left, is that correct?
Yeah, he left.
Okay. When he left, the police came, is that correct?
Correct.
Do you recall speaking to an officer?
I recall speaking to the officer at work.
How long did you speak to him?
Not long. I can't.
Minute?
Don't know how. I'm sure the officer would put the time in there, but maybe it was a few minutes. You have to confirm with the police report.
Okay. But you spoke to him.
Yes.
Did you tell him that Mr. Toledo was there because you were having an affair with his wife?
No.
Did you tell him you didn't know why he was there?
No.
So you didn't lie to the policeman?
I did not lie to that guy. That showed up. Policeman.
Just after that sometime, I'm assuming, is when you asked to go home early?
Correct. Yeah.
You went home early and saw your wife, is that right?
Correct.
Did the police come to your house that night? The 22nd?
No.
Somewhere in that evening is when you began exchanging texts again with Ms. Suarez? Or even if you didn't exchange them, you received them, or whatever was going on?
Well,
Is that right?
what do you mean, whatever was going on? So sometime in that evening, can you clarify that?
Yeah. Did you hear from Ms. Suarez that night? Or her phone?
Yes.
Okay. Your wife was there then, right?
Yes.
Your wife knew you were receiving those texts, right?
Yes.
You were trying to ignore those texts, right?
Yes.
You did tell your wife generally what happened at your office, is that right?
Everything except the affair.
Well, did you tell her that you were accused of that?
Yes.
So she knew something was going on, right?
Yes.
And then you started getting the text messages. And she saw them, right?
Yes.
She was asking you about that, right?
Correct.
She was asking you, why is Ms. Suarez texting you if nothing happened?
Well, I can't remember exactly what she said then, but she was, yes, concerned what was going on here.
So finally, you'd gotten so many texts that you decided to call her.
Correct.
Nobody answered right away until you sent a text.
Correct.
Now, when you spoke to Ms. Suarez on the phone, when she called you, right?
Yes.
In response to that text.
The text. Yeah.
You say that her speech was slurred. Is that what you said?
Yes.
Do you know what she'd been doing prior to her calling you?
No.
Do you know if she had a drink?
No.
Do you know if the day was so upsetting for her that she took a sleeping pill?
No.
Do you know if her kids were sick?
Don't know.
Do you know if she was sick?
I don't know. I told you what I know.
Okay. You said she was stressed,
Yes.
and the conversation with you was stressed?
Say it again.
The conversation with you on the phone was stressed?
The conversation with me on the phone, how I felt that she was stressed. Correct.
Do you think that it would be stressed if, for her, because the affair was exposed?
I believe so.
So when you're not saying that this conversation was forced or stressed because Mr. Toledo was doing something to her, are you?
Objection calls for speculation as to what the witness may know about.
Sustain.
Because he doesn't know. So, okay.
Objection.
Counsel, I've ruled. Next
No.
question, please.
I'm sorry, I was just trying to clarify it.
Counsel, I've ruled.
I got you. I forget how long that conversation lasted, sir. Do you know how long it lasted?
Yeah, you got the records.
A few minutes? Was it a few minutes?
Yeah, you can refer to that, please.
Okay. The next day, the police came to your house, is that right?
Yes.
The police came to your house more than once, isn't that right? More than one agency came.
Yes.
So who came first?
I don't know what agency came.
They came in your house, right?
That's right.
Your wife still doesn't know that you had an affair, does she?
No.
And the police are in your house.
Well, I can't say she doesn't know at that time.
But
If
you
I was
haven't
having
admitted
an
it
affair, I haven't admitted it, yes.
Okay.
And the police are in the house.
They're in your house. And then later on that day, they were in your house again or in your yard interviewing you because Ms. Suarez was missing. Isn't that right?
Yeah, out back, yes. Mhm.
You stayed out back because you didn't want your wife to hear it. Isn't that right?
I can't remember. No, I went out there and asked them, can I smoke while we're talking? That was the reason I was out there. I don't believe my wife was, I don't know if she was upstairs or downstairs at the time. But if you're alluding to if I was trying to hide and go out there to not tell her, if she was right there, I probably at that time would have went a way to talk, but I don't think that had a. I was out back, and I'm not for sure where she was at, and I was smoking a cigarette. Yeah.
May I have a moment, Your Honor?
Yes, sir.
May I approach?
You may.
The record's deposition, page 75, line 7. Sorry for the delay.
Thank you.
So, sir, do you recall me asking you, was your wife there when they were talking to you? And you said, my wife, no. My wife, no, N-O. Because at the time she did not know. And then I asked you, but she wasn't there, and you said, where? And I said, well, this was at your house, right? And you said, at my house. At my house, she was upstairs or inside. Do you remember that?
Yes, and that's what I just said.
Okay. Later on, you were asked to go to the Volusia County Sheriff's Office, is that correct?
Yes,
And you did that, isn't that correct?
that's right.
And you took your wife with you, isn't that correct?
Yes,
So when you say that you told your wife about everything, that's really when you did it, isn't it?
no, it's not.
You did it, you didn't tell her on the way to the Volusia County Sheriff's Office?
No.
Did you tell her after?
Well, yeah, after, but
Because you
you
were...
mean that same day?
Say again?
What do you mean after?
Let's just clarify it. You were asked to go to the Volusia County Sheriff's Office, is that correct?
That's right.
You went there with your wife, is that correct?
That's correct.
At that time, she still did not know that you were having an affair with Ms. Suarez.
I still did not tell her.
Still hadn't told her. You went there to be interviewed because she was missing, isn't that correct?
I went there to interview to explain of the night. I don't think I even knew about it being missing or her being missing or anything like that. I just can't.
You don't think you knew that she was missing by then?
I didn't know what happened at that point.
But they talked to you when you got there, didn't they?
Now, yeah, but
They-
not about
they
her.
talk-
They were only concerned about. I'm sorry.
Go ahead. They were only concerned
They
about what?
talked about her. They talked about asking me the questions, not about what was going on. I still didn't. I was still in the dark and didn't know.
You were still in the dark and didn't know?
Well, I could put things together and figure out that something bad has happened. And I actually believe that's what I was told. It's just it's not a good thing that we're here and what happened.
They searched your house, didn't they?
Yeah, they looked through my house.
And welcome back to the Law News Network. I'm your host, Amy Dash, and you were just listening to testimony from one of the victims, Mrs. Suarez's supposed lover, who she worked with. They were co-workers. And basically the prosecution is saying that was the motive for Luis Toledo to kill his wife and her 2 children. He found out that she was having an affair with the man that you saw on the stand, Kevin Drerden. And we're here with LawNewz trial analyst Deborah Blum. Why do you think that his testimony is so critical to establishing the motive?
Well, he says it himself. I was having an affair with her. Anybody's husband is going to be very angry if their wife is having an affair. He also talked about how his own wife was suspicious of this or would become upset if he was text messaging with another person, because people have feelings and they know when their spouses or partners are cheating on them. So it's very natural, and I think it is a natural reaction to have a heat of the moment killing. I'm not endorsing that. I'm not saying it's okay, but that's why we have that as a mitigating factor. When somebody is charged with a murder, they could have a lesser included due to the fact that it was a heat of the passion type crime, which this is.
And even Toledo seemed to have an awareness of that. He said in the interrogation, he acknowledged, yeah, there are heat of passion crimes. It seems he was familiar with that term. And so there is evidence to establish that that could have happened because things came to a head the day before his wife and the children went missing, when he showed up at the workplace and very publicly confronted everybody. Can you tell us about some of those details that came out during his testimony?
Well, it's very damaging to the defense. This witness said, yes, I saw them arguing at work. So that's totally a motive building factor. You know, the Suarez was found out, and that's why she's dead. It's a tragedy. You know, I disagree with how the defense handled this. I think that they cross-examine this witness too much. Sometimes as a defense attorney, you need to make a judgment call that there's nothing that you're going to get out of the witness that's going to serve your client. So I think to keep this witness on the stand and embarrass him further, I mean, look, it's not great that he had an affair. I'm not endorsing that, but again, that happens. It happens frequently. So this man had an affair, and then the woman he was sleeping with, Yesenia Suarez, ended up dead. He must feel horrible about it because he admitted on the stand that he heard her voice was off. Maybe he could have saved her life.
When he called her later that night to check on her because the husband had gone through the office place, running up and down the halls, screaming that his wife had an affair.
Right.
Because he allegedly put spyware on her
I'm sure
phone.
he feels awful, and like now he has to sit on this jury and tell everyone about his affair. I feel horrible for him. I feel horrible for his wife. And the defense just needed to keep it short and simple and said they were trying to trap him, and he wasn't going to be trapped.
Yeah, it's a tragedy all around. I want to switch gears for a second because while we're waiting for Toledo trial to resume, because they're on a lunch break, I want to preview a trial that we're going to be covering possibly as early as this afternoon, and that is the trial in Michigan, the state of Michigan, versus Jeffrey Willis. He is accused of the murder of a young lady, Rebecca Blech, and there she is. You can see her right there. But he's also going to be facing charges later on in a separate trial for murdering another woman named Jessica Hiringa, and there she is. So we have a local journalist who's been following this case, Dana Chiklis, and she works at Fox 17 in Grand Rapids, Michigan. Dana, are you there?
Yeah, hi.
Hi, how are you? Very interesting case because it appears that they found this guy years after these supposed murders took place, at least years after one of them took place, and were able to connect him because he tried to kidnap another woman and she escaped. Tell us about how that botched kidnapping led to his charges in these other cases.
Right. Well, first of all, it's a really interesting case here. Obviously, this is a very high-profile murder case. And like you said, the defendant in this case, who's about to go on trial in the next 30 minutes, Jeffrey Willis, he's charged in 3 relatively high-profile cases. You've got the alleged kidnapping and murder of Jessica Hiringa. That's another mother who was located in the southern part of Muskegon County. We have the June 2014 murder of Rebecca Blech, which is the trial we're about to start this afternoon. And then you have the April 2016 attempted kidnapping of a 16-year-old girl who got away. And all of these crimes happened within about a 12-mile radius of Willis's home. What's interesting in this case is, like you said, a lot of the evidence that has been introduced came from the 16-year-old girl who got away. Her testimony in the preliminary hearing for the murder of Jessica Hiringa. So you've got these 3 very high-profile cases, all intermingled, and what we're going to see happen is the prosecution introducing a lot of evidence from these other cases. And a lot we know already, but a lot more, of course, is going to come out in this trial that is slated at this point to last about 3 weeks.
Now, Dana, the 16-year-old girl, did she positively identify Jeffrey Willis as the man that tried to kidnap her? And do you think she will take the stand ultimately in the case?
She did, and that is the hunch that she's going to have to testify during this trial. Of course, we don't know if that's going to happen or not, or in what part of the trial that may happen. But yeah, she's referred to in court as MJN. She's not been named. We have heard testimony from her before. And, it was in the morning. She had been trying to find her way. She was lost, and she tells police that a man who she now identified as Jeffrey Willis was driving a silver van, picked her up, and she wanted to use the phone. The whole thing was she was lost and she needed to make a phone call. Well, when Willis allegedly told her that his phone was dead, she started to become a bit panicked and tells police that he reached for a gun. Now, she says she was able to crawl out, get out of the van. And when she did and she was running away, she says Willis got out of the car and pointed a gun at her. And she made it away running to some nearby neighbor's house. All of this testimony was shocking. We heard it about within the last year. And so, yeah, we're assuming that she's going to be taking the stand again in this trial.
So she jumped out of this moving van in very dramatic fashion, of course, that's what you want to do, and just started running. And later when police went over to examine the van and they got their hands on this Willis character, they look in the van and they find syringes filled with liquid sedatives in the glove compartment. What else did they find in this van of horrors, which they say was a vehicle used not only for abduction, but they believe for a sexual assault and rape?
They found a lot. And so this, again, came out in the preliminary hearing for the murder of Jessica Herringa. And so they found a toolbox, and that was in the silver minivan. And in that toolbox, I think actually on top of it, was a picture of a woman's body, a graphic drawing, and on it were points of injection and listed, which point on the body would be the quickest response of whatever you're injecting. Now, inside that toolbox, we saw in the courtroom opened, like you said, syringes, a ball gag, handcuffs. What he had tried to say, Willis himself was saying insulin because his wife was diabetic at the time, he told people. But so many disturbing things in that. And so that search of that van is what ties these three, if not more, outstanding cases together. And it also led to searches of his home and another property that was owned by Willis's grandfather as well.
And then after he's arrested, even more incriminating evidence comes to the surface when somebody contacts the police station, says that he's been harassing her, and more importantly, the police find a file on his hard drive with one of the victims, Jessica Herringa's name on it. Tell us what else was uncovered subsequently after his arrest.
Well, what we know from police who testified was that in one of the homes, I believe it was hidden in a rafter in one wall, and it was a hard drive, like you said, and on the hard drive was a folder labeled VICS, VIX, and in that were the initials of Jessica Herringa, Rebecca Bletch, and possibly others. Within that, I believe it was clippings of articles, publicity of those crimes, and missing person searches, which were, for Jessica Herringa, it's been 4.5 years at this point. It also led them to find a lot of other things. When they went into the shed on one property, they found women's underwear rolled up. I think it was wrapped in aluminum foil in the rafters of this shed. They found also nearby was a list of printed out serial killers. And I believe police said that they saw an asterisk marked next to a pair of serial killers who, I'm not going to go into that, I'm not sure, but they saw listed of serial killers. And then they also found, along with that hard drive, something, so much stuff, but I think the victim file was what was really key in seeing these victims' initials listed for police when they found that.
Right, so this guy, all evidence points to the fact that this guy could be either a serial killer, if there are more victims that we don't know about, or an aspiring serial killer, because he seems to have this scrapbook of all of these missing women. Do you know if there's an investigation into potentially linking him to other missing persons cases in the area?
Not that I know of outside of Jessica Herringa at this point, but along with that victim folder and the images you're describing, I do remember detectives testifying and saying what they found on that hard drive and other hard drives in the house was some of the most disturbing videos that they've ever seen. These were graphic pictures, videos of women being sexually assaulted, of people being killed in horrific ways. That again, the detective who was testifying saying in his entire lengthy career, this was some of the most horrific images he had ever seen. And whether those were movies or what, they didn't get into. So a lot of disturbing things. And I will say, jury selection in the case against Willis for Rebecca Bletch just wrapped up within a half hour. It lasted about 2.5 days. But what we just heard the defense tell the now seated jury is that, listen, my client is involved in sexual behavior, a sexual lifestyle that many may not agree with. But I want to make sure that all of you as jurors can put that aside and realize that Jeffrey Willis is not on trial for his sexual morality. He's on trial for the open murder of Rebecca Bletch, as well as a felony firearms charge. So it's an interesting point to bring up today. And we also saw several people dismissed as we got down to the final round of jury selection today. But we also saw within the hour, one man was randomly picked, and he took the seat next to 13 other possible jurors. And he said, Judge, I have to say that it's really been weighing on my mind the last couple of days that my daughter had said previously that she was at a gym and she thinks she saw Jeffrey Willis. And he said, she told me that he made a weird look at me. And he's like, I got to be honest, I don't think I can be impartial about that.
Wow.
Didn't say when that happened, but he was obviously excused. So a lot of these stories coming up of people allegedly seeing him in the community, but very interesting that his own defense attorney also made that a very important stress point today, that, his sexual morality is something you might not agree with. But that's not what he's going to be on trial.
Oh, yeah, sure. He's a sexual deviant, but he also happens to have a hard drive with all of these women's names on it, too. Okay, we'll dissect that here at LawNewz and see how that's going to play in court and how they're going to overcome all of the other damning evidence aside from, oh, my guy just has a little bit of a fetish, not buying it. But thank you so much, Dana. I really appreciate it. We look forward to seeing your coverage on Fox 17 with this case.
Thanks so much.
Take care. So, Deborah, what do you think of that? That the client's a sexual deviant defense.
I wouldn't say that that's what I would go with. I'm not really sure what they're supposed to go with here, because I think this is another case that really looks like a loser for the defense. Sometimes
a loser defending a potential loser here. I'm not saying that he committed these killings, but clearly he's a sick individual.
Well, I don't want to judge him for his sexual proclivities. I think that that's what his defense attorneys were trying to say, is that you should not judge him for that. That's not what he's necessarily on trial for. Although it's all related, I think that it's very damaging that you have one victim of his atrocious acts who survived, and she's going to be able to identify him, or at least that's my understanding of it.
Yeah, but the fact that the police are saying, and the reason why I labeled him sick is the fact that the police are saying that the videos and the pictures that they saw were some of the most disturbing things, in combination with the files on these specific missing women and this van of horrors where he has a toolbox. It all seems to add up to the fact that there's a very good chance he was doing some things he shouldn't be doing. I mean, if he's idolizing serial killers, something's wrong with the man, right?
Definitely.
Would that be a logical conclusion?
I would have to give it to you, yes. There's something very wrong with this individual. As a defense attorney that has over 10 years of experience, not much shocks me, but a case like this does shock me. And once I actually have a ridiculous anecdote. You know what? I'm not going to share that one because it's very disturbing.
You just teased us.
Yes, it's a very disturbing one, and there are so many disturbing things that come across my plate. And we were talking about this earlier. Sometimes, as a defense attorney, it gets gets to be too emotionally draining that you're dealing with people that are accused of committing these atrocious crimes. And usually you're able to connect with your client and see them outside of what they're charged with. But in a case of this magnitude, where he's alleged to have done these really disgusting things to women, I don't know that I would be able to defend him. And I rarely say that. You know, this is a case where you have one woman.
You have a low moral bar.
I wouldn't say that either.
Low standard.
I don't know if I'd say that
You said that there's some that you rarely turn down cases, right?
You know, I'm being more selective nowadays. I actually defended someone that was accused of a manslaughter, and it really was difficult for me, and I didn't realize that I was going to feel that way. I thought that my client was wonderful. Everybody who interacted with him really was shocked that he had taken somebody else's life. So that was a young man who really, that was tremendously out of character for him. But this guy, I don't think that you could elicit the same sympathy for. And you know, I don't know enough of the facts here, but it really seems like you have one woman who survived, thankfully survived. And
identifying him.
Right, exactly. So I don't know how you get around that as the defense attorney. I'm not sure if this is a state with the death penalty and that they're trying to spare him the death penalty, or what they're really trying to accomplish. Probably it's the type of case where he's not being offered any plea deal whatsoever. He's being offered the max. You know, it's not a deal. The judge isn't willing to budge. I can understand why in a case like this. So really the defense is left with no choice but to go to trial, hoping they're going to be able to find reasonable doubt. I just don't see it here.
Yeah, and actually Michigan has a really interesting history with the death penalty, as you brought up, because actually it was the first state to ban the death penalty and was very opposed to it for many, many years. So it probably won't come into play in this case. But what you're talking about anecdotally reminded me of this cannibal cop moniker case here in New York City, where we had a New York City police officer who was accused in a conspiracy to kidnap, eat, and rape and do terrible things to women. I covered the case, actually corresponded with the cannibal cop in prison for 2 years because despite how disturbing his words were in fetish chat rooms, because that's how he was communicating his fantasies in these fetish chat rooms, despite all of that, he didn't take any actions outside of the chat rooms that were substantial enough to constitute overt acts in furtherance of the conspiracy. So I was able to say, okay, maybe this guy has some sexual deviant fantasies, but he shouldn't be convicted on conspiracy unless he took actions outside of it. Here, I can't make that justification because you've got a guy with tools in his van trying to kidnap a woman who escaped, fantasizing about rape, and idolizing serial killers. So it takes it to a whole nother level.
I mean, he definitely did those steps. He most likely murdered 2 women, and as you said before, maybe others that we don't know about, although it seems like in this town they're hyper aware of what's going on. They knew about Jessica Harenga's disappearance. I don't believe they ever found her body. I know that they were trying and continue to try, and they finally pieced this together, and they're holding this man accountable, and it really seems like he is the perpetrator of these crimes. And interestingly enough, you brought up that you were able to correspond with the cannibal cop, and I remember that case, and I remember that it was a tremendous victory for him and his defense team that he was not convicted because he did not do overt acts. It was just chat room things, and you know.
And it set a precedent, which I'm sure you could talk about too.
Right. Well,
the fact that you cannot prosecute people based on their sick thoughts alone.
Right.
Or if you don't want to categorize them as sick, deviant.
Right. Well, in a case like that, I think the right thing is going to end up happening. I'm sure he's getting mental health treatment. People need help. And sometimes what others don't realize is that this could happen to people and it's not so hard. Look, the cannibal cop is an extreme example, but I recently had a client who went onto Instagram, got into these conversations with young underage women. At first, I don't think he realized that they were underage, but then he realized it and he exchanged pictures with him. And I am not encouraging that behavior. That is not acceptable whatsoever. But he had a wife and a young child and a job. And if he would have been indicted on those crimes, all of that would have gone out the window. His whole reputation would have been shot. His wife would have had to suffer the consequences of her husband losing the job. And fortunately, through my work, I was able to get the police, it was a joint federal and state effort, and I was able to have them not prosecute the action, and he has to get help. And that is the right thing. I think sometimes...
So he didn't take any steps, you were saying, just to clarify for people, outside of sending a picture, which you don't agree with, but in this case they decided that he would be better suited through mental health.
Yes, and that's what he's doing, because sometimes people have these, it turns out was touched as a young boy. It's not an excuse. None of this is an excuse, but...
No, but it's important to acknowledge the origin of how this comes about, because there is a cycle a lot of times when people have been abused themselves and grow up to be abusers. So I think if you don't acknowledge it, then we can't advocate for help for those people to stop that cycle.
Right, and this man is now getting the help that he needs. His wife knows about it. He's in treatment. And I think that it's very commendable that law enforcement made the decision based on the fact that there were no overt acts. He simply exchanged pictures with these young girls, and they were sending pictures as well, and they're underage, so they're not held responsible, nor should they be. I'm not saying that either. It's just, it's so easy to get entangled in this, and I really think that it was the right thing that now he's been put on the map. I'm sure that law enforcement is going to follow his actions online, and if they find out that he does something again, he will have the book thrown at him. But sometimes in life, people deserve a break. This man was deserving of a break, but it's completely different than the case that we're going to follow next week here at the LawNewz Network, where this man went through and murdered 2 women.
Potentially, yeah.
Potentially. I've already made my,
And you're a defense attorney.
I am, and I'm usually very pro-defense,
right.
And I'm really,
But you're convinced here.
I am convinced here, as well as in Toledo, that there is going to be a guilty verdict.
Mm-hmm.
And
yeah,
I don't
really
even really know that much about this matter, but just listening to the local reporter, I think that there's enough of a nexus to get a conviction.
Yeah, and it's interesting that you said that the person that you had represented is now being monitored, that's a positive thing, that now people have their eye on him, because when this guy was arrested, after he tried to kidnap a 16-year-old, which is undisputed because there's going to be testimony to that effect, I was thinking, and then they found all this other stuff, I was thinking, thank God that he's off the street. And we don't know what he's done over the years. I mean, now he's connected to 2 cases that were unsolved for quite some time, years later. But how many other people could there be out there? I think the files that they found on his hard drive could potentially lead to other cases that he may have been involved in, or other abductions or attempted abductions. But will that all come in? I mean, if there are missing person files on his computer, aside from the victim in this case, will that come in? Well,
those are uncharged acts. So there's a standard for the prosecutor will make the application. I'm not sure how extensive they have a file, if it's going to link him to anyone else. If it does, most likely the prosecution is going to want to bring in those uncharged acts. And then the defense attorney is going to argue a whole litany of reasons why it shouldn't come in. At the end of the day, anything that is an uncharged act is highly prejudicial to your client. And he is solely on trial for the criminal acts that he's facing here. So all of this additional stuff, although I understand the reason why the prosecution tries to bring it in, motive, identity, if identity is an issue, but I don't know that any of those things are an issue here. I don't know enough about the case, but I really think then that the possibility of the jury convicting him on those outside acts becomes really significant and severe, and that again leads to an appealable issue. So. Yeah. It seems like here that they are going to bring up these other acts. You're going to have the witness testimony of the young lady that was able to escape and survived. Mm-hmm. So they're already going to know about other acts. So I don't see why they then need to bring in any additional ones, or why the judge would allow that. Yeah. And so when she testifies, because she's just 16 years old, how do you prep a witness like that? And also the fact that she's so young, is it somewhat horrifying for her to have to go up against this guy? What if he's not convicted? Then he's on the loose again, and she says that he tried to kidnap her. She's a young girl.
Is there
Well,
any type of safeguard for that?
I can't imagine being that 16-year-old woman. It must be horrifying for her to have experienced what she did, and now she's reliving it over and over again, and she's going to relive it in court. As a defense attorney, I once had a client that was accused of sexual misconduct, and it was, I would say, 100% not true. The jury found my client not guilty, and I had to cross-examine a 13-year-old girl about it. And it was very difficult because you feel horrible that you're subjecting this young woman to cross-examination, but that is sometimes a part of your job, and you have to do it skillfully and take into account that that young woman is the age that she is. Here, at least this woman is 16 years old, so she's a bit older, but you really are hesitant as the prosecutor to bring in somebody that is under the legal age, but here it's really a necessary link.
Do you think that any of the defenses carry any weight here? I mean, we've got the sexual deviant defense here, which I don't buy into because there's so much other evidence that shows that this was way more than just a guy who's fantasizing. But then also they find liquid sedatives in syringes in this guy's vehicle, and he's trying to make the excuse that his wife had some sort of a medical disorder, but it wasn't a medication, it was a sedative. So how do you overcome that if you're the defense?
Again, I'm really not sure what the defense is going to do here. I don't envy their position. I think there are so many facts that link him to the crime that it's a tremendous hurdle to poke any holes in this. You know, maybe the wife did have a prescription for the sedative. That's really the only way I think that they could use that defense. Otherwise, how did she have it? Why did he have it?
Right. Exactly. And so what about some of the other evidence that they found in this vehicle? Just so happens that the vehicle, and I want to quote this because this is a great quote. It says, this was a vehicle designed to not only kidnap, but also take sexual advantage of women. So this is like a rape van, basically, is what they're saying. And they found handcuffs, rope, all these sick things. Do you think that finding those items is enough to connect him with these murders?
Well, there's going to be an identification.
In and of itself, the van, right.
No, I don't know enough about this case. I don't know, did he admit to having the van? Did they find it on his property? Is it linked to him in the sense that, does he have title of the vehicle?
So they're going to have to establish all of that stuff before even bringing any of this evidence in, right?
Right. Well, they're going to have to show the nexus between him and the van. So I assume there is one because it seems like this young woman testified. Well, I don't know how they're going to prove that the van is his. So that's something that I'm curious about, because once they're able to establish that it is his van, I really don't see how you're going to explain away all of those things unless maybe his wife testified that it was like their place that they would go to live out their deviant sexual behavior. Other than that, I really don't see off the top of my head how you could explain that to a jury.
What about this woman who contacts a news station and says that Willis has been stalking her? Do you think that she'll come in, or is that too prejudicial absent evidence? And if they do have evidence, will that get in?
I think that would have to be proven to some extent, and it's possible that it'll come in as an uncharged act because it's yet another woman that he threatened and made fearful. So it is something I think the judge is going to consider. I think that in this day and age, people are usually able to prove these things. They're able to show text messages, or they're able to show social media exchanges or pictures of the person following that individual. So I would need to know more to tell you if I think it's going to come in. But again, it is the same thing. It's highly prejudicial. He's not on trial for that.
Yeah, exactly. And lastly, his cousin lied to the police, then pled guilty to lying to the police. How does that tangential item of evidence factor into the charge?
Well, I'm not sure if the cousin pled guilty and was given some kind of immunity or what the deal was. Maybe he would have to.
It says he was sentenced to time served.
Right. So that means that he got a slap on the wrist. As his defense attorney, if he was going to testify, I certainly wouldn't want him to have a criminal conviction. I would want him to be spared that in exchange for his testimony, but I don't know if he was going to. offer testimony here, and I don't know that people would find him credible. So sometimes when you have such a strong case, if the state has a strong case, which it seems like it does here, you're not going to need the testimony of somebody that was involved in this crime.
If he lied to police about the abduction of Jessica Haringa, that's going to be a separate trial. Can that come in to this trial if he takes the stand?
Well, it might not, because he would have an agreement with the state. So he lied.
Immunity, you're saying, from testifying.
Right. Because he lied to law enforcement, and defense might not be able to attack his credibility either, except, you know, it seems like people here that live in this town would know about these cases, and they probably already know about all of this information, and I'm not sure exactly what's allowed to come in, which crimes are coming in, which ones aren't. So for me to give accurate analysis, I'd need to know a bit more about it, but it seems like the state has a strong enough case that they really don't need the cousin's testimony. And as we've seen in other trials here where people are not credible, that have criminal records, juries don't tend to believe them, and then it ends up going to not guilty or a mistrial.
Why do you think that they decided to try these murder cases separately? And is that usually how it's done?
Well, oftentimes separate cases are tried separately. Even in cases of co-defendants that are accused of committing the same criminal act or criminal acts that are linked together, you're going to have separate trials. But in this instance, it really makes sense to me that they're completely separate incidents. So you might not be able to get into Jessica Haringa's murder here because he's still awaiting trial. Rebecca Bleich is going first, so there is no conviction on Haringa.
So how does that change then if he's convicted on Bleich and then it goes to Haringa? Does that conviction then come into the Haringa case?
But that's a separate application. So that would be during a hearing that they'd have prior to the trial. Once he would be convicted of that, defense then would be able to argue that that's too highly prejudicial and all the other things that we argue, and try to keep it out then. But if it's an open case, it's